So the context for VASM, as it exists within the college, is both a terrific exercise that the college has initiated and been going for some years now in relation to the quality and safety space, but VASM is also a requirement for CPD within the college. So CPD of the college also reflects the CPD that you're required to undertake for the medical board. So we have a sort of almost universal acceptance of involvement in the audit of surgical mortality across Australia for that reason. So that's a good thing. Try again. There we go. The issues with having an audit of surgical mortality of this nature, where frank and fearless information is being provided, analysis, potential admissions that things could have been done better, the confidentiality of the doctor, obviously the privacy of the patient. There is a fear of litigation. It is throughout the medical profession. No one likes to be sued anyway, but it is an issue given the history of medico-legal litigation and the insurance crisis not that long ago. And of course, it's also an issue which may affect credentialing in hospitals as well. So to address those issues, the college, as part of the establishment of the surgical audit program, applied under Commonwealth law for protection of what's called qualified privilege. So ASM is a registered scheme under the Commonwealth legislation. It also applies to ASNIPS, but it says that the information collected through the audit of surgical mortality must be confidential. No identifying information of patient or doctor can be used outside of ASM itself. And if someone revealed identifying information, it is a criminal offence under Commonwealth law, punishable by penalty and imprisonment if it's a really serious one. So pretty severe sort of protection of the confidentiality. This is better than the Privacy Act. It's better than some of the other stuff that's around. This is about as good as it gets. So our assurance to surgeons in being frank and admitting issues and errors and what went well and what didn't go well is that there is statutory confidentiality attaching to it. The information within ASM cannot be subpoenaed. It cannot be released to a court. A court can't require it to be disclosed. The only time it can be is if the minister, that is the Commonwealth Health Minister, is satisfied that a serious crime has been committed. So it must be sort of at the level of manslaughter or murder before identifying information can be released. And the information, the other part of the obligation is that the people involved in having this information verified or used for college purposes must have natural justice applied to all processes in which they're involved. So natural justice requires that there be assessment of the relevant criteria. There must be only consideration of the relevant material, an opportunity to be heard, notice of adverse information. The people who make the decisions are unbiased, and there must be a review mechanism. That applies to all processes of the college and is rarely used in relation to ASM because there are no real consequences for people other than the broad discussion of issues, a second-line assessment, and ultimately some broad de-identified case studies and recommendations. The other issue in relation to providing information and using information within ASM is people are worried about being sued for defamation. So second-line assessors who may say, well, I didn't think that was done as well as the other surgeon thought it was. All commentary, all information within ASM is free from defamation. The only time that defamation can apply to any sort of commentary within college processes where we're assessing people, that includes the training program, assessment of IMGs, for example, is where the comments are made malicious. That is, they're made not really believing them to be true or made with the intent of harming or hurting someone. So again, a fairly high bar. Otherwise, most, again, of the college processes have that protection, which assures you to be able to give a frank and honest opinion. It may not be a correct opinion at the end of the day, but if it's a frank and honest opinion, then you're protected. With patient information, we obviously need to get consent, and we have a privacy statement. So again, when you are using information, your privacy statements will enable you to use information of patients for sometimes research or educational and training purposes. Again, with the ASM requirement, hospitals who participate in ASM obviously have either an ethics committee approval or they participate through this being explicitly part of their privacy statement. So that's how the information comes to us. I think the only other issue that's really relevant to VASM at the moment is, of course, the government has reflected on ASM, as did the Western Australian government some years ago, because although this is a quality and safety exercise, there is always pressure to access this information to find out where the bad eggs are. So it's not just improving quality, it's, well, how do we know whether we've got a bad surgeon or not? And the college's answer has always been, that's not why it's here. This is a quality exercise, it's for improvement, and don't mix up the two. If you want to have an exercise that assesses surgeons and assesses them to find the bad ones, then you have your own process. You work out your own system. You should be doing it within your own hospitals anyway, and hospitals will have M&M committees that can look at things. They may be protected by qualified privilege as well. They're not as well protected in Victoria as you might think. So VASM is the better way to go. But we are resisting government requiring that we reveal who are the bad eggs within the process. We are, however, in discussions with Safer Care Victoria as to ways to improve VASM by having a second-line assessment being a multi-professional assessment, not just surgeons, but the people who undertake the multi-professional assessment will still be under the restrictions of confidentiality that our scheme applies to them. And it may be that we can also involve hospitals who get hospital reports generically as well, get more detailed information about what's happening in their hospital, but again, they will receive the information and they cannot use that information outside of the ASM process. But they're matters for discussion, and we're very concerned, of course, to make sure that any changes that are made reassure surgeons that the information that is acquired through the process is protected. I think that's a key issue. We've certainly told government that if you require anything else, then people just will not participate in ASM no matter what we say. So I think that message is getting through. So it's broad brush, top line VASM, the protection is there, it's real, and it's designed to protect people. So happy to answer any questions.